Hello everybody, my name is Laura Hallett-Lee and I'm a Senior Associate Solicitor at Forbes. Today we're going to talk to you about Landlord Complete, and that is a service that we offer to our landlord clients who are wishing to evict their residential tenants. So first of all, just an introduction. Myself and also Samantha Abdullah, who's a trainee solicitor in our team, is due to qualify very soon too, and then she will be a solicitor in our team. So I'm going to talk to you first about the service that we offer. So we offer a fixed fee service where we receive your instructions, documents and a checklist which we can send through to you. After we've received that, we promise to give you the initial advice for a fixed fee within 2 working days. After that, we'll make a recommendation as to the route of possession. Sam will be talking through with you the routes to possession, and then we will deal with the effect of COVID-19 and other frequently asked questions that we get as a matter of course in the Landlord Complete work that we do. So over to Sam to deal with the ways that we can gain possession.
There are 2 routes to gaining possession of your property. The first is fault-based under Section 8 of the Housing Act 1988, and the second is non-fault-based under Section 21 of the Housing Act 1988. Now, the reason why a person might utilise Section 8 is where there are significant rent arrears by their tenant. If your tenant is in 2 months or more of rent arrears, this is a mandatory ground and the courts will issue you with your possession order. If your tenant is in less than 2 months of rent arrears, then this is a discretionary ground and the courts may issue you with your possession order. Section 21 of the Housing Act 1988 is a non-fault based process where you don't need to have a reason to be looking to take possession of your property. There are hurdles that you need to jump through, however. At the outset of your tenancy, you need to provide your tenant with evidence that their deposit has been protected in a deposit protection scheme, a gas safety certificate, an energy performance certificate, and a how to rent guide. Now, if the reason that you are looking to take back possession of the property is in relation to complaints by your tenant of maintenance issues or disrepair, this could be classed as a retaliatory eviction, and unfortunately you wouldn't be able to rely on Section 21. Now, the notice that you need to give to your tenant depends on the type of notice that you're giving and the reasons for doing so. And unfortunately, with the current pandemic in place at the moment, the courts have issued new guidance as to how much time you need to give your tenant to vacate the property. I'll now pass over to Laura, who will explain a bit more. Laura.
Thanks, Sam. So one of the most frequently asked questions we're getting at the moment is how COVID-19 is impacting residential landlords. Well, there's 2 ways that landlords are being impacted. The first is that although the legislation states that sometimes a 2-week notice is required under Section 8 or 2-month notice is required under Section 21, both notices now have to be 3 months in time, and that is only in place until the 23rd of August. So if you have a tenant who's in rent arrears, it may be best to wait until after the 23rd of August, where we can simply serve a 2-week notice and not a 3-month notice. Alternatively, for a Section 21, it will be 3 months now or 2 months after the 23rd of August. That is assuming that that date doesn't get pushed back again, like it did in June. The other way COVID-19 is impacting possession proceedings is that all possession actions have been stayed pending this moratorium being lifted in August. So even possession claims that we issued in January, February, March time are still stayed. So that means all of those landlords are now in a queue to get their possession hearings. So any claims issued now will most likely be behind those actions and take several months to reach a court hearing. So delay is the overall impact that COVID-19 is having on possession claims at the moment. So over to you, Sam.
Thanks, Laura. I'm often asked if a landlord wants to issue a Section 21 notice, but they haven't issued their tenant with the prescribed information. Is that going to be fatal to gaining possession? Now, that prescribed information, as already explained, is evidence that the deposit has been protected, the gas safety certificate, the energy performance certificate, and the how to rent guide. Now, the good news is we can issue your tenant with the how to rent guide and the energy performance certificate either just before we serve them with the notice or alongside the notice. With relation to the gas safety certificate, previously the position was that this had to have been provided to the tenant at the outset of the tenancy, or this would be fatal to you relying on a Section 21 notice. However, the courts have issued new guidance that states as long as there was a gas safety certificate in place at the time the tenancy was entered into, this can be served at a later date, which is excellent news for landlords. In terms of the deposit protection scheme, if you didn't protect the deposit within 28 days of receipt, it may be that the courts will award the tenant compensation, and this can be up to 3 times the amount of the deposit received. So whilst none of these issues are fatal to you, Section 21, you could end up just paying out a little bit of money in the event that you fail to protect the deposit. Laura, over to you.
Thanks, Sam. So another question we get asked is, after you've served a notice, a tenant complains of disrepair, perhaps in writing or perhaps even to the local council. What do I do? What do I have to do? Well, the short answer is you have to deal with any disrepair that is reported to you as landlord, and you should deal with that in writing within 14 days. And you should also seek to repair any landlord obligations immediately if they're urgent. However, that does not fall within retaliatory eviction. So your notice is still good and you still should be able to obtain possession, but you should deal with any disrepair, not only because you have a duty to do so in regards to the safety of your tenant, but also you could face a compensation claim.
Yes, another question that we're asked quite often is, I've issued my tenant with a Section 8 notice because they are in significant rent arrears, yet somehow they've managed to find the funds to bring their arrears to less than 2 months' worth. What can I do? And the answer to that is still continue with your possession proceedings. Whilst it's a mandatory ground for the courts to issue the possession order in the event that your tenant is in 2 months or more of arrears, they do have a discretionary power to issue you with your possession order in the event that there are arrears of less than 2 months. So if we can show a pattern of non-payment and of significant arrears, then it may well be that the courts will still award you with your possession order. So finally, back over to you, Laura. Thank you.
So the next question is, I've served a notice and the deadline's gone, tenant still remains, what can I do? You have no powers to remove a tenant without a court order, and only a bailiff can do that as well. So unfortunately, the only step you can now take legally is to issue a possession claim in the courts. So providing everything is up to scratch and you've got your grounds and the notice was served correctly, you will get your possession order. It's just a case of following due process, serving a particulars of claim and claim form on a tenant and waiting for your hearing date. There is a possibility to avoid a hearing date by using the accelerated procedure, which we can advise you on. That's just the Section 21 non-fault based route and can only be used in certain circumstances. But ordinarily there will be a court hearing where somebody will need to represent you and you ask for possession, obtain your possession order and then send in a bailiff. There is no other route, unfortunately. So that brings us to an end of the frequently asked questions. If you have any further inquiries, please don't hesitate to contact me or Sam, and we'll deal with these by email or telephone, or please just look on our website and there's more information on there. Thank you, everybody.